Ask many people today to name part of the Constitution, probably the only thing they would be able to name would be some aspect of the Bill of Rights. Yet that wasn't even part of the Constitution when it was originally proposed. The Federalists, the people who defended the Constitution, argued that this new Constitution only had powers that were given to it by the text of the Constitution, so-called enumerated powers. Therefore, it simply wasn't necessary to have a Bill of Rights. That was what James Wilson, one of the greatest lawyers in America, a prominent Federalist, said. And then, of course, Alexander Hamilton, in the Federalist, written with James Madison and John Jay, published in the New York newspapers and eventually published as a book, he argued that, in fact, not only is it not necessary to have a Bill of Rights, it would be bad to have a Bill of Rights. His reasoning is you can't list every right that you want to protect, and by listing some, you will, by implication, exclude those you haven't protected. So therefore, it was a bad idea. Now, if you think about it, many Americans today, one of the rights that most Americans think they have, and the courts certainly have defended this right, and I think most Americans do believe it's a fundamental right, is privacy. But the word privacy does not appear anywhere in the Constitution or the Bill of Rights. And in a way, Hamilton would say, see, I told you so. You know, everyone values privacy, yet we forgot to put it in there. Now, obviously, privacy has evolved under our jurisprudential tradition in a series of cases. But when those cases were decided, they were controversial because several of the justices, the most famous being Griswold versus Connecticut, the case that really establishes the modern right of privacy, several of the justices said, you know, if I was a legislator, would strike down this law or repeal it, or I believe privacy is very important, I would enact legislation to protect it, but it's not in the Constitution, and therefore as a judge I can't really find it in the Constitution if it's not there. So the problem of a Bill of Rights is really quite complex, but it does become one of the central issues in the debate over the Constitution. Ultimately, of course, obviously the Constitution triumphs. There's some compromise. And the key compromise is in Massachusetts, which has a debate, a ratification convention in the sort of the middle of the process. And at that point, the Federalists have argued against the Bill of Rights long enough that they realize it is just such an important issue to the American people. They can win over moderate anti-Federalists if they concede. And so they say, okay, we will, once the Constitution is adopted, take up the issue of amendments and we will protect fundamental liberties, such as freedom of religion, freedom of the press. And the Bill of Rights is, I think, a remarkable part of our constitutional tradition. Interestingly, James Madison thought that the Bill of Rights wouldn't really do very much. And yet, ironically, in the first Congress, he becomes the person charged with sifting through the more than 200 suggestions for amendments and whittling them down to about a list of 20, which Congress further whittles down to 12. The first 2 are not adopted by the states, and we're left with the first 10, which we now call the Bill of Rights.